if a prominent politician or someone in a key public role, such as Chancellor of the Exchequer, says something about their tax affairs which you know to be categorically false, would you make a statement at all to correct that?
I think as a general rule, our duty of confidentiality would mean that if a taxpayer made a public statement about their affairs which we felt we did not agree with, that would not be a matter that we would correct. But again, we would look at things on a case-by-case basis and decide whether, in that particular case, the issue was such that it was within our functions to disclose information. But as a general rule, our default is that we don't disclose. And it can be a source of frustration for HMRC because people will brief the press or perhaps brief MPs about their tax affairs. We will sometimes feel it's not the full story, but we have to deal with it on the basis of their disclosure because we're not in a position to disclose further information.
Okay. Would you contact the individual direct if they were of a significant public position to advise them that it was perhaps unwise to say something that was not factually correct?
I mean, as a general matter, it would depend. I mean, if we felt that a taxpayer had misunderstood their position and that they needed to understand that in order to administer their tax affairs, then perhaps we would. But if people are entitled to say what they wish to say to friends or family or press, whatever, it's not my responsibility to sort of police their behaviour in that way.
Okay. If they're in a significant position, such as Chancellor of the Exchequer, do you feel you have any responsibility to advise the Cabinet Office or the Prime Minister's Office or Number 10 generally about any behaviour that might be conflicting with their responsibilities oversight with HMRC?
So I think that's something we would have to look at on a case-by-case basis within our functions. There's no general rule. Obviously, responsibility for complying with the ministerial code and for declaring any issues in relation to the ministerial code is a matter for ministers. It's not a matter for me as an official to police or enforce compliance with a code. But on each case, we would have to consider whether in this particular case it was within our legal functions to make a disclosure. But proactive disclosure of information about taxpayers would be an extremely rare matter, I think, for HMRC to be involved in.
Okay, well, I think we're dealing with quite a rare matter. On that point, I'll move over to Sarah Olney MP.
Thank you very much, Chair. Mr Harra, I was just wondering, what does HMRC understand, or what does it mean to imply when it uses the word carelessness, that someone has been careless with their tax return, and what should the general public understand by the use of that term?
Again, I'm not commenting on any one particular person's affairs, but carelessness is a concept in tax law. It can be relevant to how many back years that we can assess, and it can be relevant to whether someone is liable to a penalty, and if so, what penalty they would be liable to for an error in their tax affairs. There are no penalties for innocent errors in your tax affairs. So if you take reasonable care but nevertheless make a mistake, whilst you will be liable for the tax and for interest if it's paid late, you would not be liable for a penalty. But if your error was as a result of carelessness, then legislation says that a penalty could apply in those circumstances. So those are the two occasions when HMRC would consider whether non-compliance was careless, when we need to understand what back years we can assess and when we need to understand whether there is a penalty due.